this is a probation violation hearing. Mr. Elhart, you've been retained now to represent Mr. Foz. Are you prepared to go forward with the hearing this morning?
Yes, sure.
Okay, so Ms. Traska, if you could please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth? So help you God.
I do.
All right, and if you could please start by telling us your name and how you're employed.
Amanda Traska, probation officer for Leelanau County with District Court.
Hang on just a moment, Mr. Elhart.
If I may, Your Honor, Mr. Foz is here to admit that he is unable to do the community service work.
Okay, so he wants to enter a plea.
Yes, Your Honor.
What about the added violations for, let's see, failed to continue counseling with the cancer center, disrespectful to court employees and care providers, and acting in a threat, intimidating, harassing manner. Okay, so then, Mr. Foz, is that correct? You're changing your plea in this case to guilty of the violations. That's what you want to do, is plead guilty.
That's his direction, yes, sir.
Okay, so it's still your decision, but I understand you've consulted with Mr. Elhart, and that's what you've decided to do.
Yes, sir.
Okay. So before I take your plea, I want to make sure you understand that you do have a right to a hearing at which Mr. Elhart would represent you, and you're choosing to waive that right, correct?
Yes.
Do you also understand that the worst that could happen is the worst thing that could happen? Do you want to talk to your attorney some more about that?
By violating probation, the worst thing that can happen is the maximum.
Okay, so you understand that, correct? Okay. Has Mr. Elhart answered all of your questions to your satisfaction?
Yes.
And no one's used any force, threats, coercion, or made any promises to you to get you to waive your right to a hearing this morning, have they?
I'm going to say no, sir.
All right. Then the report indicates you were placed on probation back in October of 2023 for leaving the scene of an accident causing an injury. And as a condition of that probation, you were to complete 30 days of community service work within the first 180 days. Is that true?
Yes.
And the fact is you did not complete the 30 days in the 180 days, correct? There's also an allegation that you failed to continue your counseling with the cancer center as ordered. Is that true?
True with extenuating circumstances. It's not true that I refuse or I'm not doing it. As I've mentioned before, a letter was sent from the parole office without my permission or knowledge to my medical providers asking for information on my medical records. When I found out about that, I called my medical provider. They said they deleted the email. This went on for about 3 months.
Wow. Buckle up, because this case is wild from start to finish. Before we even get into the courtroom audio, let's establish just how chaotic the situation really is. We have a defendant who allegedly escalated a simple interaction with cyclists into a full-on vehicular assault situation, then somehow managed to turn himself into the victim during court proceedings. And the courts? They actually gave him an enormous break because of his medical conditions, offering probation instead of jail time. You would think someone who narrowly avoided incarceration would keep their head down, follow every rule, and thank their lucky stars. But not this guy. He manages to violate nearly every condition placed on him. He fails to complete community service. He doesn't continue mandatory counseling. He blows up a court staff. He insults care providers, and allegedly acts in a threatening or intimidating manner. And when confronted with all this, he shows up ready to debate.
Me trying to get the email from my provider. She went to legally refused. And because of that letter that was written by the probation department and my asking about it, they discontinued service. They refused service because they didn't want to get involved in a legal case. I also went to my,
Okay, so I'm going to give you and Mr. Alhart a full opportunity to explain the circumstances of these violations. But for right now, I'm just trying to establish if you're pleading guilty to this. For whatever reason, you did not complete the counseling that was ordered through Cowell Cancer Center, correct?
correct, but not due to my circumstance, due to their circumstance.
The answer is yes.
Yes, sir.
Okay. So, is it also true you were disrespectful to court employees and or service or care providers?
I was honest with them.
Okay, but would you agree that you were disrespectful to them?
To me, sir, that's a very subjective term.
Well, we can have a hearing on that issue. We can
Well-
have Ms. Traska go through all of the emails and other correspondence.
I've got them too. I've got them here as well. And if you mean saying, fuck you and the horse you rode in on for writing that letter and other things like that, yes, I did.
Okay,
If you call that disrespectful, yes, that was disrespectful.
all right. So, and then,
Right here is where the stage really gets set. The probation officer is sworn in, and this is significant because probation officers don't exaggerate or dramatize. They document. Every missed appointment, every hostile email, every unfulfilled requirement is time-stamped, saved, and filed. The judge bringing her in this early signals something important. This isn't just a minor technical violation. They're preparing the factual foundation for multiple serious compliance failures. Notice how calm and direct she is. That's because officers like Amanda know their documentation speaks louder than emotions. Meanwhile, the defendant is about to learn that probation isn't a suggestion, it's a contract. And breaking that contract comes with
you can take into account whether or not you think the board is appropriate to consider for any sentence.
all right. So, Mr. Alhart, are you okay with that?
I am your.
All right. So then, Mr. Foss, to the first three allegations, how do you plead?
Yes.
Guilty.
I'll accept your plea, find it is voluntary, accurate, and understanding. And Mr. Alhart, what else would you like me to know?
Thank you, Your Honor. With the sentencing phase now, Your Honor.
Yes.
Thank you. Your Honor, Mr. Foz was, and you had received it, I think, a copy of a letter dated nearly a year ago, where he was given 2 years to live. He may not make it to his next birthday. He's under daily chemotherapy. Cancer has spread to his bones, the rest of his body, and the liver is at correct lymph nodes. I'm sure that he's undergone a great deal of modification to his temperament, the way he behaves, and to everything else due to the cancer. I'm very certain in looking at his history and talking to him about his history, what he's done for our country, that he was an exemplary citizen. Cancer has changed who he is and what he is doing. His behavior many times inappropriate. Certainly, I understand his dismay that his medical right.
This is where the defense tries to narrow the battlefield. Classic strategy. They want the judge to focus on only one violation, community service. Why? Because it's the easiest to explain away, especially with medical issues at play. But the prosecutor, or in this case, the judge and probation, immediately push back, reminding the attorney that there are multiple allegations: failure to attend counseling, disrespecting staff, and behaving in a threatening or harassing manner. Those aren't small issues. Courts take them seriously because they're signals of escalating noncompliance. Watching this exchange, you can feel the tension rise. The defense wants a surgical strike. The court is prepared.
Were violated. By the same token, I understand what was going on. He can't do any work of any kind. He can barely make it here today.
Mr. Alhart, are you aware that he was given the opportunity to consult with the probation agent to try to come up with non-physical activities that would count as community service work, such as writing letters to veterans?
I wasn't aware of that.
I wasn't aware of that either, John. That's never been proposed to me.
Right here in open court. Okay, go ahead, Mr. Alhart.
What was right here in court, Your Honor?
When we were here on the first probation violation. Okay, thank you. Mr. Foss, is there anything you'd like to add?
Yeah, there's a lot that I'd like to add, Your Honor, but it doesn't really pertain to what we're doing here today. I've been really disappointed by the professionalism exhibited by the probation department, my violation of my rights. The scales of justice don't seem to be equal. Inflammatory language, refuses, inflammatory language like that, it's not accurate. It's not true. I never acted in a threatening, intimidating manner. What I do demand is service from my public employees, and refusal of service is unacceptable to me, and that has happened.
Here the judge does something extremely important. He slows everything down. Anytime a defendant waives their right to a hearing, the judge must ensure the waiver is knowing, voluntary, and intelligent. This prevents appeals later claiming coercion or confusion. What's interesting is how the defendant answers quick, short yes responses with very little elaboration. That often signals someone who wants to move past the formalities but may not fully appreciate the consequences. And the judge's tone? Calm but firm. He's essentially saying, I'm giving you every chance to understand what you're doing. Judges are meticulous about this because once the plea is entered, the court has wide discretion to impose the original sentence.
Requests. I'm not familiar with how the legal system works, but when I am refused service, it makes me a little irritated. I expect professionalism from my public employees, and I admit I've not been professional. I've been irate, and I get that way very easily. Part of it's, as we mentioned before, testosterone has a huge impact on that. It changes your personality. I had a doctor's appointment last week, and I mentioned that to my doctor, and he said it's an effect of testosterone. And the reason I'm unable to perform these tasks is because of my testosterone levels, my chemotherapy, my sicknesses. The reason I missed my last appointment for probation, and I mentioned this to Ms. Trask, I wrote her a letter. I'm very sorry I missed the appointment. I was ill. I don't get my mail every week. I apologize, and I asked her if there was something I could do to mitigate the situation. I never received a reply. So it's not that I'm fighting and refusing to do what you're asking me to do. I will happily do, if I could, sir, I would happily do what you asked me to do, but I'm not physically able to do it. I've mentioned that I would be happy to pay a fine to help out the community, but physical activity service, yeah, I'm not able to do it.
All right. Mr. Chamberlain, anything for the people?
Your Honor, I agree with Mr. Foss that the scales of justice are not equal in this case because he was charged with a felony and could have been charged with 2 others for felonious assault. Your Honor, he got mad at someone who flipped him off. He turned around, drove his vehicle right at them, slammed on the brakes, and one of the people got hit. That person was in the hospital. They had their leg split open for, I believe it was 4 days with a pressure bandage. So from about the top of the knee to about the top of the thigh. And that was due to his actions, due to, as he said.
And there it is. The defendant finally pushes back and reveals he didn't fully grasp what probation actually is. Many people think probation replaces jail, but legally, probation delays jail. If you violate it, the court can activate the original sentence. The judge clarifies this, but the defendant's confusion shows he believed the case was done after sentencing. This misunderstanding is more common than you'd think, but in this situation, it's a major issue because the violations include confrontational and threatening behavior. When a defendant doesn't understand the stakes, they often act recklessly, and here the judge is emphasizing that the consequences are very real, up to a full year behind bars.
And his anger, Mr. Elhart said, cancer has changed him. Well, then that means he's a public safety risk. Your Honor, because I ran the guidelines in this case, and had he been convicted of just what was on here, he's looking at 0 to 14 months. Had we increased it to the 2 additional felonious assaults, it would be 7 to 23 months. That's OV1 for using a vehicle as a weapon, OV2 for the potential lethality of the weapon used, OV3 25 points for life-threatening and permanent incapacitating impairment, OV4 10 points serious psychological requiring therapy and other medical intervention. OV9, number of victims. There were 2 to 9 placed in danger. OV17, 10 points for driving recklessly.
This moment highlights the judge's attempt to recalibrate the defendant's expectations. Probation isn't a reward, it's a second chance. And that second chance disappears the moment you violate its terms. The narrator interjects with strong commentary here, expressing frustration with the leniency of the original sentence, especially given the severity of the underlying charge, leaving the scene of an accident causing injury. These are not victimless violations. Real people were harmed. Meanwhile, the judge sticks strictly to the